People often ask, what is the difference between legal custody and physical custody of the children in a divorce case or an allocation of parental responsibilities or a custody case in Colorado? And what's interesting is Colorado uses different terminology that is more specifically aimed at the real question, which is who gets to spend time with the kids, where and when, and who gets to make decisions about the children's schooling, religious upbringing, extracurricular activities, etc. We know these as parenting time and decision-making, or parental responsibilities. And these are the same whether it's a divorce or whether you were never married, but you need a court to help decide and determine who has what rights to the kids. This is also, of course, very often tied up with child support. The difference, what a lot of people talk about physical custody, and you'll often also hear people talk about sole custody, split custody, and various such things. That is all with parenting time in Colorado. And the presumption in Colorado is that parenting time should be evenly divided, that it is the child's right. It is the child's right and in the child's best interest to have relatively equal time with both parents, circumstances permitting. That's where we start. And then you can present evidence and help the court to understand why that might not be the best result for the child. Legal custody is known in Colorado as the decision-making protocol, right? The parental responsibilities. Who will have decision-making authority over such things as education, as religious upbringing, as healthcare, as extracurricular activities, and other things that are important in the child's life. Again, it is the court's predisposition that these things should be shared, and that whenever possible, the parents should agree on all of those questions. But where they can't, the court will sometimes award one parent education, the other parent religious upbringing, and split it up in that way. Or in some cases, they'll give all of the decision-making to one party or the other. This is particularly done where there is a history of abuse, where the court is convinced that trying to force both parents to come together to make decisions would not be in the best interest of the children because it would lead to more conflict, and awards the decision-making to one side or the other. But so physical custody is parenting time. Legal custody is the allocation of parental responsibility, decision-making, and we bring these together to talk about how the parents are to bring the children up as a co-parenting relationship whenever possible, and what the rules are when it's not. In Colorado, child support is calculated fairly formulaically. There is a child support guideline that has been promulgated by the state, and lawyers must calculate, parties must calculate the child support by the guidelines. It doesn't mean that you have to go by the guidelines, that the child support award must be exactly to the guidelines. The court can be convinced to deviate from the guidelines. And by the way, as it goes to parental responsibilities and parenting time, also with child support, the court must approve any arrangement that you come to with the parent of the other parent of the child. And so when you figure out the child support, you have to present the child support calculated according to the guidelines to the court, and then tell the court how you want it to be different. If you want it to be more, if you want it to be less, if you want it to be paid in a different way, if you want it to be paid in kind. There are innumerable ways to do it differently than the guidelines, and as long as the court can find that it is in the child or children's best interest to do so, the court will award a deviation from the guidelines. But you must calculate the guidelines first, so the court honestly knows what it's deviating from and can then weigh the best interest of the child in doing so. In making decisions about parenting time, about decision-making, parental responsibilities, parental rights, child support, and other things in a divorce or an allocation of parental responsibilities or a custody action, the guiding principle for the courts is the best interest of the child. In everything they do, the court must find what is in the best interest of the child. And even if the parties agree, when the parties agree, they still must present to the court why that agreement is in the best interest of the child. So a question often comes up is like, how does the court know? How can the court determine what is in the best interest of the child? And this is most effectively done through the presentation of evidence, usually by a law firm, that guides you in presenting the evidence that the court is going to be most interested in knowing in order to be able to determine what's in the best interest of the child. The court also will sometimes rely on and require outside experts to also present information that is important to the court to determine the best interests of the child. For instance, one of the most common is a child and family investigator, CFI, is appointed in a case to be the court's eyes and ears in determining what's really going on in the households and bringing that evidence and recommendations to the court for the court to consider in determining what going forward is going to be in the best interest of the child. There are child legal representatives who are actually a lawyer appointed or assigned to the child or children who stand in court on an equal footing with the lawyers of each party to present a case from the child's perspective, from the child's interests, representing the child's interests to the court. All of these things can be done in combination or individually to help the court with the question of what's in the best interest of the child. To be effective, it's important to show the court that you have the best interest of the child at heart and that that is your primary focus and not your own best interests. In Colorado, child support is determined through a formula. There's the child support guidelines that each party must complete and present to the court in helping the court to determine whether child support from one party to the other is in the best interests of the child. One of the primary factors in making this calculation and determination are the incomes, or is the income of each party. That is not the only factor, but it is certainly an important one. The overarching theme is that the child, not the other party, has a right to the resources of the child's parents in raising the child, supporting the child. It is child support. It's not parental support. And so one of those resources that each party has available to do that, of course, is that party's income and the other party's income. To make it very simple, the way the guidelines kind of work is that you add both incomes together, you take a percent of that income, and that percent is determined by how many children there are. And that's the amount that of the party's combined income that should go to the support of the children. And then what that total amount is then divided and weighted based on which party has the same income or which party has more income or which party has less income. That's how it's done. One of the calls that we get very frequently are of parents who've been through a divorce or an allocation of parental responsibility or a custody fight. And either they don't like the result that happened or that the result that happened no longer works. And they want to change custody. And they want to know, is that possible? Is it possible to change parenting time? Is it possible to change decision making? The answer is yes, absolutely. It is possible for good reason. It's also possible for no reason at all. The overriding rule, without getting too nuanced here, is that once a decision has been made, you have to wait 2 years to ask the court to change the rules of the parenting time or the parental responsibilities, unless there's been a substantial change in circumstances that warrant the court taking a look at this sooner than that. And then if you can prove the change in circumstances, for child support that one party's income has changed substantially, for parenting time that the needs of the child have changed or the party's circumstances have changed, for decision making, again, if the needs of the child have changed or the party's circumstances have changed in some way, that the court should entertain a change before the 2 years is up. So first, before 2 years, you have to prove these changes. After 2 years, you can just go back to the court and say, we'd like to revisit this. A frequent call for us is a parent who has gone through a custody dispute, either through a divorce or outside of a divorce, and had the court make a decision, or even come to an agreement with the other party as to parenting time, decision-making, child support. And they come to us now because the other party's just not abiding by that agreement or not abiding by the court's order. The agreement now being the court's order. And they ask us, can you help? The answer is absolutely, we can help. There is a mechanism with the court called an enforcement, where you ask the court to enforce the orders that had previously been put in place. You can also ask for the court to use its contempt power to cause the other side to come into compliance. These are different strategies that are useful in different circumstances, and each has its benefits and its drawbacks. And depending on your case, we would advise you as to which avenue, or both sometimes, to pursue. But the courts are absolutely there to enforce their orders and to enforce the decisions, whether they were made by a judge or by agreement between you and the other party, as to what the parenting time, parental responsibilities, decision-making, and or child support should be in your circumstance. As part of a divorce or as part of a disagreement with the other parent of your child, you may want to seek a court determination of who gets to spend time with the child when and where, or as Colorado would put it, where the child will spend time with the child's parents when and where, what the support will be from each parent for the child, who will make decisions for the child. And the question becomes, well, how is that determined? The best way, the newly family way, is to first seek, if at all possible, agreement between the parties, to try to promote the future that you want for your child or children. What are the circumstances you want for them a year from now, 2 years from now, so that you don't put it in the hands of a court to decide for you, to take this most important decision as a parent out of your hands. To the extent possible, we'd like to keep that decision in your hands and agree with the other side. And agree often means a little bit of compromise. Where agreement can't be found, then it is our job to promote the best interest of the child as you try to advocate for the parenting time and the decision-making and the child support that you believe is in your child's best interest. And in order to do that, if agreement can't be reached, then it becomes a matter of presenting the evidence that the court needs to make its determination. And that evidence is going to be very largely about what parent can promote a good relationship between the children and the other parent, and what parent will fight hardest for the best interest of their children as opposed to themselves. And there are so many different ways to present this to a court. And we are very experienced in finding the best ways, and quite honestly, in working with you to make sure that your head is straight on this, that you can rise above the conflict and rise above the fight and have it clear in your head why what you're proposing is in the best interest of your child or your children. Because once that's clear to you, making it clear to the court becomes much, much easier. So we work with you as well as with your case, as well as with the court, in order to present a set of circumstances and a set of facts and a set of beliefs that the court can sign off on as indeed being in the best interest of your children.